welcome to Unpublished Opinions, an Institute for Justice roundtable podcast, the podcast where IJ attorneys get together and give their unvarnished and unpublished opinions about the law. I'm your host, John Wrench, the Assistant Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this today on November 12th, 2025, and I'm joined today by my IJ colleagues, Sam Gedge and Josh Windham. Sam and Josh, welcome on the show.
Thanks, John Wrench.
Thanks for having me.
So on most of our podcasts, we end up talking about things, unsurprisingly, that are related to either the attorney's specific work or IJ's litigation in general. But I've been thinking recently, like a lot of our legal ideas, whether it's through law school or the things we're interested in after, are formed by a bunch of things that we don't end up necessarily litigating. And so I've been thinking about how those maybe less relevant legal ideas or areas of law have influenced how you think about the law in kind of big ways or small. And so that could be from a class that you've taken or books that you've read in areas that might not be directly relevant. Josh, do you have any of those things that have kind of shaped the way that you think about law?
Yeah, I read a book when I was I don't know if I was late undergrad or early law school, but it was by C. Bradley Thompson, or at least edited by him. It's called something like 19th Century Abolitionist Thought or 19th Century Abolitionist Writing. And if you read it and read through the essays in there, like one of the things you take away from the abolitionist tradition is sort of this sense of moral righteousness and optimism about the future. And that has really impacted the way that I think about our work. Obviously, we're not out here fighting slavery, to say the least, but we are people who get into the law because we think there are big problems in it that seem intractable at the time, right? Like things that maybe we'll talk about this later, but maybe there are legal trends today that we think seem pretty deeply entrenched and deeply rooted that we'd like to see overturned or changed during our lifetimes. And I think one of the things that the abolitionist tradition teaches is that you actually can create pretty revolutionary change in the law, in the legal system at a fundamental level through the course of intellectual persuasion. Now, of course, there was a civil war, and we don't want to have to resort to that to get our way here at IJ. But the point being, like, you could even fast forward to Brown versus Board and Plessy versus Ferguson being overturned and kind of that later part of the tradition, the post-Civil War tradition of civil rights activists. And that was a period of 20 years from when Thurgood Marshall started litigating these cases to eventually winning Brown versus Board. And, I just think of that as bad as the law might seem in some of the areas we litigate, or as big as some of the problems that we try to tackle appear at the outset, in the span of a career, all of that can change and look so much better. So that's kind of something I turn back to when I'm maybe lacking optimism or seeking kind of renewed energy, and reminding me kind of like where my roots are intellectually and why I got into this stuff.
Yeah, that's really interesting because when you were talking about abolition, I'm thinking of another famous lawyer who was extremely influenced by abolitionists in Boston and ends up fighting in the Civil War and believes in many of those ideas and then ends up believing in not much at all afterwards. I'm thinking of Holmes. And I find that very interesting because that seems like one off-ramp of I believe in this thing, but it's very hard and it has consequences. And I'm not sure that I see the light at the end of the tunnel. And one off-ramp of that is there's this extremely jaded view that actually you probably can't change things.
Yeah. I think if I'm looking for sort of a paragon, a figure that I look to for inspiration, John Quincy Adams is such a great representative of this, because I think after he was president during the Amistad controversy, he actually got involved as a pro bono lawyer for the folks who were captured, and there was a question of, well, what was their legal status? Were they slaves? Were they free? And that was this huge public controversy at the time. It was in all the papers and everybody was intrigued by it. It was sort of one of the first big public interest cases in the United States that made national headlines. And of course, there was a victory in that case. And that was not something that established that, slavery was unconstitutional or anything like that. It was a relatively narrow win for the prisoners there. But the point being, I think it was sort of a chink in the armor of slavery. It was a chink in the armor of that sort of grave injustice, and recognizing that like you could build wins against it through a legal system over time that would one day accrue to something much bigger. So at IJ, we do tend to start small and build our string side out, and take things case by case, and one day hope to make progress against big evil things like the open fields doctrine.
Yeah.
The Amistad movie, as you probably know, is a good movie. 2, filmed in Connecticut, my home state, and 3, I believe, the only feature film in which a Supreme Court justice is an actor. Justice Blackmun, then retired, played the judge in the Amistad movie.
I did not say
That's very interesting. Wow. That's a good piece of trivia. I guess I had one quick follow-up question, which is, it sounds like all of that has definitely made you, it's like a reservoir of optimism that you can kind of draw from, especially in litigating the stuff that we do. Would you say that it has changed your view about people's reactions to when we begin litigating something or when there are losses early on?
Well, I just think that, when you set out to achieve something big in the law or to make big legal change, you have to recognize that you are fighting an uphill battle. And so, even if a win seems narrow, against the kind of mountain that you're fighting against or trying to climb, it's still monumental in context, right? Like the smallest wins are still wins where there were no wins before. Mm-hmm. And so it allows them to kind of appropriately assess the importance of even marginal victories at the outset of a big campaign or fight. And 2, I think, you have to, it's baked into the cake in some sense that you're going to have pessimism about the cause, skepticism about it, people who think that you're pursuing something quite radical just because you're trying to change the way things have been for, a century or more. And so, I think it just sort of gives you an appropriate understanding of what you're all about, what you're involved in, and doesn't, you don't overreact to criticism and you don't overreact to losses because you expect the road to be hard.
Mm-hmm. Sam, do you have any similar legal ideas or areas of law that have kind of influenced the way that you think about your work?
I will give you 2 because neither is as profound as Josh's. But the first, I'll start with an analogy, John Wrench. When I was young, I used to take piano lessons every week, and Did you enjoy it? Well, so at first I did not. In fact, for several years, I think many years, I did not. I was kind of agnostic about it. I just did it because I did it. And then one day I happened to listen to a recording of a Chopin waltz, I believe, Opus 64, I believe, number 2.
Wow, that's very specific for. I think it might have been this.
So it actually might have been number 1. Yes. Well, one of your listeners can fact check that. And it really kind of opened my eyes because it was the first time that I like heard it. I was like, oh wow, like this is what kind of like really working at piano can sound like. This is really moving. This is really impactful. And it really, like, I remember it now, potentially down to the actual opus and number of the waltz, or possibly not. Only time will tell. And I've long since kind of like lost my piano skills, but for several years, like that was kind of like the inflection point where I was like, oh, like this is something I actually can enjoy and can want to get better at. And I had a similar experience kind of with the practice of law, maybe 3 or 4 years out of law school, where I just happened to read a Supreme Court cert petition, I think in like 2014, 2013. And it involved kind of like the effect of a jury discharge. I think the court had discharged the jury and they had started walking down the hall, and then the judge was like, wait, come back, come do this other thing. And they came back and they reached a different verdict. And it's like, is this okay? And it's an area of law that I had no real relevance to me then, has no real relevance to me now. But kind of reading that document, I was like, oh, like, wow, like this is what good legal writing looks like. And it really kind of like, registered for me in a way that it hadn't before. And for many years after that, and even now at time to time, I make a point to just read good legal briefs by people who are good legal writers. And I don't care what the topic is. In fact, I often prefer that it not be one I know much about or not have much interest in, because I'm reading it not to like learn about ERISA or jury discharges, but to try to understand what it is about the brief that educates me, that makes these topics feel easy to me or persuasive to me, so that I can try to kind of develop those skills in my own writing as well. So that's the first possible answer to your question. The other kind of more off the wall answer is that I've always been fascinated by the kind of the peculiarities of the legal regime in the early 20th century on the island of Rhodes and the surrounding Dodecanese islands, because it's just this fascinating little nugget of history, John Wrench. And we may have talked about this before. Anytime you kind of let me off my leash in this podcast.
Actually, somehow this hasn't come up.
Oh well.
At least
buckle up.
At least not around me, but I promise you, I'm very excited.
Guys, we're recording in the morning. Sam didn't even need a drink.
From about 1520 to 1912, the island of Rhodes, which is in the Mediterranean, the Aegean, was a possession of the Ottoman Empire. They had seized it from the Knights of Rhodes, the Knights Hospitaller in the 1520s. And ethnically, it's overwhelmingly Greek. At the time, there was also a small Jewish population as well. But in 1912, the Italians took over the Dodecanese Islands as part of the Italo-Turkish War. Italy had invaded Libya, which at the time was also a Turkish possession. And the war had expanded to the Dodecanese Islands, the island of Rhodes and its surrounding islands. And the Italians occupy it in 1912, and the Italians actually maintain occupation of these islands until 1943 or 1945 during World War II. And what I've always thought, there's many things fascinating about it. We can talk about it as long as you want, John. But one thing that's always fascinated me about it is that it's this kind of potentially a unique peculiarity where you have one European nation essentially colonizing what they would recognize as another European community, right? Like in the late 19th century, early 20th century, it was entirely common for European countries to colonize Africa, Asia, all sorts of communities that they kind of viewed as like ethnically or racially less than. Like that was just fully accepted during this period.
So more like us colonizing Canada, that would fit in the...
Yeah, it's timely as well, John. But you have like the Italians like colonized this largely Greek community, and the Italians were very sensitive to this, so much so that like they created this peculiar legal regime specific to the islands that was deliberately different from the legal regime they had imposed on Libya and Eritrea and Somalia, where they had kind of these more traditional hierarchical legal systems against like communities that they just viewed as like not equal to theirs. So instead of having like the officers in the islands report to the Ministry of the Colonies back in Rome, they had that report to the Ministry of Foreign Affairs. They wouldn't call it a colony; they called it a possession. They created this kind of little citizenship for the people on the islands in a way that they never would have for the African people in their African colonies. So that has always just fascinated me, and given the breadth of your question, John, I feel like it fits, broadly speaking, within the spirit of your inquiry.
Yeah, that's fair. I think so. One of the things that's fascinating about that is, do you know whether that accommodation was due to them being, just for practical reasons, concerned about not making the accommodation, like sparking some kind of response to it, or was it really just this? We happen to possess the region that you live in, but you are more or less part of the same kind of general larger community, and so we're going to make an accommodation for you.
I think it was a bit of both. So even within the first months of the occupation in 1912, the Greeks on the islands at first were thrilled because they famously don't like the Turks. There's this bad blood between them. And they thought, oh, great, the Italians have taken us over. It's just going to be a matter of weeks or months before they turn us over back to the Greeks. We can be part of the Greek nation. The Italians very quickly made clear, like, actually, no, we're going to keep you guys. And in fact, they kind of brutally suppressed some efforts to kind of have the islands reintegrate into Greece. So there was definitely a lot of tension there. But I do think there was also just kind of this kind of like weird mismatch between like, it's kind of a colony, but we think that these people are white and we don't want to kind of say that they're colonists because like that doesn't totally match with how we view imperialism and colonialism. And Anyway.
Although I feel like vassalage was a relatively common tradition on the European continent, like in the centuries leading up to that. So now this sounds like it's a step beyond mere vassalage, where they're not just sort of saying like, hey, put our flag up and we collect taxes from you, but instead they're saying like, we're going to impose a kind of government on you, even if it's not the one we might impose on more far-flung colonies.
Yeah.
So there's something between vassalage and full colonization going on here.
Exactly. Yeah.
It's interesting because it seems like, well, I don't know what context you read this in because it could have been something drawn from this, but this sounds like such a interesting case study that someone, I assume people have done PhDs on, because it's the mixture between a bunch of different legal regimes, it sounds like, that don't really exist on their own in nature. So it's like an artificial one. So did it work? Did it ultimately work? Did it fall apart? I mean, you have like, military conflict, but do you get the impression that it would have continued working but for the military conflict?
So I don't know. I think when things really started going off the rails, as with many things in the 1930s, John, was the advent of fascism, and so things took a really bad turn in the mid 1930s. Like they imported the racial laws, which had become common, obviously in Germany, but in Italy as well. And then in 1943, with when Italy surrendered to the Allies, to General Eisenhower, there were a bunch of German soldiers on the island too, because the day before they had been allies, and the Germans kind of brutally took over the island, imprisoned, killed a lot of Italian soldiers, annihilated the Jewish community. They almost all got killed. So no, it didn't work out well.
But we'll never know in some ways if it would have, except for the war, but for the war, I guess.
Right, and the advent of fascism.
And fascism. Fascism does ruin a lot of things.
Yeah. Unpopular opinions from John Rich.
Yeah. One of the things I wanted to note, because I think of this often, is this idea that the first thing you said, experiencing Chopin or experiencing very high quality briefs or things like that, I do think that it's really helpful to experience excellence when you're in the stage of muddling through something. And I think that could go for basically anything. It could go for a craft you've taken up. It could be about a sport that you're learning. Because I think sometimes, especially if it's a deep thing that takes a lot of time to master and a lot of skill to master, it can be easy to think that you just don't have the thing that would allow you to master it. And it is true that people who are probably like the very, 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 very top, like they have some special sauce for sure. But at the same time, I think people also underestimate the amount of work and self-improvement it takes to probably reach that point. So seeing that excellence, I think, is very helpful. Whether it's a brief and that's, oral arguments. I think modern day Supreme Court advocates, by and large, I've listened to a lot of old oral arguments. Modern day advocates are so polished and so high quality.
God, Neil Katyal's argument in the terrorist case was so good.
It was good.
Just shout out to Neil. That was amazing.
It was good. Yeah, it is great to be able to experience a level of excellence in those things. But I do think that it can keep you playing piano, or at least appreciate it looking back.
I have to say this. I would not want to live in a world where I was just the full-on best at something, because then I wouldn't, I relish improvement, and I feel like it gives me a sense of purpose to kind of strive ever upward. And if I were the best at something, then I wouldn't have others to look to, like Sam Gedge as a writer,
or vice versa. Your tables of content, Josh Windham's tables of contents, just sight to behold.
But yeah, it's when you have others who are sort of your superiors at something, you can look at that and say, that's a data point I can strive for, or at least work into my repertoire and do a little bit of trial and error and see if try that hat on for a minute, see if it works for me. And without those things to kind of drive you forward or pull you forward to create yourself, that's scary.
Right. And then you end up in a situation too where you go through that experience of saying, where's the room where all of the people who know what they're doing is, and then you realize that you're the room, right? And that has its own kind of, I am the best at this thing, which for most, I would actually hope that most people are humble enough that would be a scary thought. But I don't know if that's necessarily true.
That has been out there in church.
Yeah.
Indeed. It's similar though. And I know you have several other things on your agenda.
Oh no, this is great. Do you have another island
I mean, we can talk about Liros or Kos. We have all sorts of islands. There's 13 of them.
Whatever you were going to say.
No, I mean, it's similar, right, to the way I understand, like, artists to train, right? Like, I'm not going off of like apocryphal stories.
I mean, you're an artist in your own right.
Maybe in certain ways. But right, like when you're like training to be a painter, like you kind of like go to the museums and you kind of like you copy Michelangelo or whatever. And I think there's a lot of value to that, right? Because you're kind of like seeing what works. You're trying to imitate. And likewise, like I often kind of like imitate. I'm not trying to be Paul Clement, like that would feel artificial and would not be persuasive. But just like seeing what works for people and incorporating that to Josh's point into like what works for you, I think is a huge part of the learning experience, not just for like junior lawyers, but for even graybeards like me and also very experienced beardless people like Josh.
I mean, people who are excellent at anything or elite at anything, at the very least, give us a sense that there are tools out there we might not have tried using before. And so even if we don't try to be Paul Clement or be Neil Katyal or whoever, knowing what the tools are is a big part to figuring out who we can be.
For sure. Sure. Speaking of tools, we're going to pivot to some history and tradition. So the Supreme Court has kind of refocused a lot of, at least the analysis of constitutional rights on what people kind of call history and tradition, as like a test, maybe like a loosely defined set of ideas or a test. And we see this in the Supreme Court's decision in Bruin, the gun case. We saw it in the Supreme Court's decision in Dobbs, the case that overturned Roe versus Wade. And those cases analyzed the existence or scope of rights using this kind of focus on history and tradition, both the nature of the right and laws that exist at the time, burdening the right or not. And it's been a few years since those cases, and I was wondering what you think about kind of where we are a few years out. Like, do you think that the history and tradition test is more or less accurate, a good thing, a bad thing? Do you think it's confusing? Has it migrated into other areas of how people think about constitutional rights? Has it impacted your litigation? Just kind of stuff like that. Sam?
Yeah.
Any ideas about that?
Yeah, I do have some thoughts, John. So I think there's been a lot of intelligent people who have said a lot of intelligent things about the text, history, and tradition test. And so when I was thinking about what I would say, I was sensitive to not just wanting to repeat what like the folks on advisory opinions have said for hours and hours, because that they've said it better than I think I could. But I guess I have a couple of thoughts. Like one, kind of whether we like it or not, it is here and seems to be here to stay and is expanding into other areas of constitutional law. And kind of you can't just wish that away whether you like it or not. All right. So here at IJ, we have an attorney, the inimitable Daniel Nelson, whose full-time job is to do historical research in cases that are suitable for it. He does a great job at that. And so we've certainly tried to adjust to this kind of new world where, history and tradition, whatever it might mean, is more a part of many judges' analyses. But yeah, I mean, there are a lot of criticisms about it, that it's not workable. For example, that judges are not historians. There was I believe a federal judge in Mississippi who I believe tried to appoint expert historian witnesses to try to flesh out the history, which I think was perhaps something like a performance piece on his part. But I think drives home that like, how exactly is this supposed to work? The thing that bothers...
Can I pause you?
Yes, please.
Can you, for the listeners, just say what history and tradition, like, what is this framework we're talking about here? Whether you or John, you asked the question, do you want to define it? I
think that's part of the problem. I mean, I think that would be, you could say it's part of the problem, though I think someone would defend it and say, generally speaking, when the court is being asked to determine the existence and scope of a right, it will look back usually to founding era history and the history that led up to that, immediately surrounding it, to try and determine through law. I mean, basically any relevant sources, which put that aside as which are the relevant sources. Which period of time is relevant is another difficult thing. How far back before the founding do you go? Is it the immediate area around the founding? What about the practices in the 20 or 30 or 40 years immediately following it? But loosely speaking, the court is looking back at that era to try and determine whether a right existed, and if it did exist, what the scope of that right was. And one of the ways that it also will judge whether a modern law violates that right is to kind of look back to see whether there's a relevant analogous law at the relevant time. Yes, or a tradition of such laws.
Yeah, I just want to clarify that we're talking about a method of, I take it, clarifying ambiguous constitutional text, or at least constitutional text that doesn't spell out its meaning for us. So like a word like liberty, these are ostensibly tools for giving ourselves some kind of legal meaning for a term as capacious as liberty, or something like cruel and unusual punishment. So these are tools among many different tools that judges have employed over the centuries for figuring out what does the constitutional text mean. So I always took the test to be text, history, and tradition, just to clarify that.
Yeah. No, I think that's a good point. And especially this idea that through most of American legal history, there's kind of a tool chest. And I think one of the things that this question is aimed at, and I would say I think is true that it's a trend to make it more of a, if it's not the only tool, it's at the top of the hierarchy of tools. And maybe if there's stuff that's used after, it's only if, it's almost like the chevron steps of like, is it ambiguous? And if it's not ambiguous, like this idea of if only after text, history, and tradition it's ambiguous, can you even think about using anything else? And even then, I'm not sure that some justices would say that there is an alternative. You have to figure out using text, history, and tradition. But yeah, I think that's generally what we're talking about.
Well, but no, that's fine. I mean, just to build off that, right? Like the perhaps novelty of it now is that it's not limited to words like liberty, right? Where, okay, what does liberty mean? It's cropped up in the Second Amendment context. It's cropped up to a degree in the First Amendment context, and we can talk about that. And maybe the answer is, well, okay, every jot and tittle of the Constitution is ambiguous in one way or another. But it does seem to be, kind of, as I understand it in recent years, like the part that seems a bit novel to me is that when you're talking about laws that undisputedly trench on one of these enumerated rights, like the right to bear arms or the right to free speech, what you see courts doing under this rubric of text, history, and tradition is, well, despite that, instead of kind of applying the tiers of scrutiny, for example, or some other legal standard that has been developed and been in place for quite some time, instead we're going to look back to some time in the past and look for some kind of historical analogs or the absence of historical analogs for this type of challenge law, and that can either be dispositive or not of the question of whether this current law is valid or not. And for me, what has been most troubling to me is kind of the procedure of it in a way, which may come as no surprise to either of you. But I looked at the Bruin decision this morning, which was kind of the marquee, the coming out party for the text, history, and tradition test. This was the Justice Thomas's Second Amendment decision where the court struck down one of New York's gun control laws, and it was all about text, history, and tradition. Like, we're looking at historical analogs to old-timey laws and X, Y, and Z. You have that, and comparing that to Justice Thomas's opinion in the First Amendment context in a case called Vidal versus Elster, which involved a challenge to a trademark restriction. But basically, the trademark law says, I'm going to butcher it, but that you cannot trademark a phrase that includes somebody else's name without that person's consent. And the actual dispute there involved someone trying to trademark the phrase Trump too small. And there too, you have Justice Thomas writing for, in part the court, in part just a subset of the court, and applying a similar kind of text, history, and tradition test to uphold that law. And those two cases, I think, bother me because I think there's just to me, there seems to be some fundamental inconsistencies with how the same authoring justice is applying what purports to be the same test. Because if you look at the Bruin case, the Second Amendment case, throughout, the court is saying, the burden, we're in Second Amendment world. This law that's at issue here does implicate the right to keep and bear arms. And so the burden falls on the government to show that its law is consistent with this historical tradition. Only if the government can carry that burden can we uphold this law. The court also says, it's not our burden as the court to go out on our own and start doing our own historical research. What they say is we are not obliged to sift the historical materials for evidence to sustain New York statute. That is respondents' burden. That is the government's burden. In response to concerns that this is kind of like this open-ended historical inquiry, how on earth are we supposed to do that? The court in Bruin says, we can apply the usual evidentiary tools that we normally do. They invoke this idea of party presentation, basically that, it's up to the parties to present the historical record that they think is relevant. The court is entitled to decide a case based on the historical record compiled by the parties. Presumably that means the historical record compiled by the government, because it's the government's burden here. All of that sounds like it kind of makes sense. And you fast forward a couple of years to Vidal versus Elster, which again is this First Amendment case involving a challenge to a trademark law under the First Amendment. You have the same justice authoring, and you have the court saying, okay, this case absolutely implicates the right to free speech. The court says this, in fact, is a content-based restriction on speech, because whether or not you get this trademark protection turns at a granular level on the content of your speech, right? Because it has the word Trump in it, Trump too small. That's why this law says that you can't get it registered without President Trump's consent. So ordinarily, we'd be applying strict scrutiny to a content-based restriction on speech. But the court says, hey, we're going to do a really deep dive into text history and tradition, and we're going to conclude that based on history and tradition, this is the rare exception where a content-based restriction on speech doesn't trigger strict scrutiny, doesn't trigger any First Amendment scrutiny. And what troubles me though is because when you look at the opinion and you look at the briefs in Vidal versus Elster, the government actually never said squat about history and tradition in their briefs. The government was presenting its arguments, understandably, in kind of traditional doctrinal terms and saying, well, actually, this law involves, a condition on a benefit. It's not a restriction on speech. It's just citing standard issue First Amendment principles. There's no discussion of history. There's no discussion of tradition. Neither party raises it. Certainly not the government, who, right, if we're taking Bruin seriously, it's the government's burden. If we're taking Bruin seriously, the courts are constrained by the principles of party presentation, where we're supposed to be relying on the parties to present this information. And that really just kind of all goes by the wayside in Vidal. As far as I can tell, the first time anything about history and tradition cropped up in the case was when the opinion was published.
Know if there were amici on that question?
There were a few amici. I don't believe, I don't know. I looked at the names of them this morning, and there were no legal historians weighing in on legal history in the name of the amicus brief. Yeah. And on top of that, right, it sounds like the history and tradition analysis in Vidal wasn't obvious, right? You have Justice Barrett writing the separate opinion saying, actually, I think all of the history and tradition in Justice Thomas's opinion is wrong. And you again have kind of these seeming inconsistencies with how he's applying it, right? Because if you look at Bruin in the Second Amendment context, the court says, we're not going to look at anything to do with the history in the late 19th century or in the early 20th century, because that couldn't possibly bear on the question of what the Second Amendment meant, at the founding or at the ratification of the 14th Amendment. And then you go to Vidal versus Elster, and one of Justice Barrett's critiques of of Justice Thomas's opinion is that most of it's looking at late 19th century and early 20th century history. And so there's a lot to be said about the problems and the shortcomings and the kind of unpredictability of the text history and tradition test. But I think just looking at these two marquee Supreme Court cases really kind of drives home that, what is even going on here? Who actually has the burden? Is it a situation where the party who the court wants to lose has the burden? That can't possibly be it. So anyway, I've been talking for a while, Josh. Well, feel free to weigh in.
I'm really happy that you mentioned Justice Barrett's concurrence in Vidal versus Elster, because I love it. I think it at least rhymes with a lot of concerns that I have about the text history tradition framework, and I just want to quote a few things that she said, given that Sam had the luxury of quoting. So she wrote, and I think this is really, really great stuff. The court does not and could not argue that the late 19th and early 20th century names restriction tradition serves as evidence of the original meaning of the free speech clause, nor does it treat history it recites as a persuasive data point. Instead, it presents tradition itself as the constitutional argument. The late 19th and early 20th century evidence is dispositive of the First Amendment issue, she says. Yet, what is the theoretical justification for using tradition that way? Relying exclusively on history and tradition may seem like a way of avoiding judge-made tests, but a rule rendering tradition dispositive is itself a judge-made test, and I do not see a good reason to resolve this case using that approach, rather than applying a generally applicable principle. And then she goes on to talk about how she would derive a principle from the constitutional text and the governing history or the relevant history surrounding the adoption of that text. So, like,
she's gotten a lot of hate, I would say, over the last year or two for being perceived as essentially like not a true believer in the court's approach. But she's a critic. But she's a very thoughtful critic.
She's very thoughtful, and I think that what she's careful to do. Like later in this opinion, for example, she cites McCulloch as an example of a court applying a more principled approach. And when I say principled, I don't just mean more correct, but I also mean one that reads the law as a set of principles rather than a set of historical data points. And I think she's getting at something that really concerns me about this tradition or this approach, which is I don't really buy the notion that judges are unequipped to do the kind of principled reasoning that she's advocating for and that Sam kind of alluded to earlier when talking about, I'm not saying tiers of scrutiny is necessarily like the end-all be-all only right way to do constitutional law, but it is you're thinking in principle, you're applying principles across, different types of cases to reach, a framework that a court could apply in a general matter. In a general way, rather. And I think what Justice, if you go back and read Dobbs, for example, there's a lot in Dobbs, and Justice Kavanaugh has written about this in other opinions too, but like judges just aren't equipped to do, the kind of interest balancing, weighing of pros and cons. That's a policy question for the legislature. We don't do policy. History's hard, but it's easier to do history, and it's more like judging to go sift through historical records than weighing costs and benefits. I just think that's a false dichotomy. Like it paints judges as if they are mere appliers of formulae, and all you need to do is give them the algorithm, give them the input data, and they'll spit out the answer like a calculator. When judges are thinkers. And judges have to be thinkers, and they have to be independent thinkers, and they have to be capable of thinking in principle and recognizing that our constitutional system is a system of principles. And if judges can't do that, they're not doing judging, as I see it. Now, that's just me, Josh Windham, talking on this Unpublished Opinions podcast, and that's just my unpublished opinion, man. But my point is, I have real concerns about this approach, not just for some of the reasons that Sam flagged and for some of the ways it can be abused in practice, but because I just think it's off base. But to kind of capstone that a little bit, I mean, we at IJ are making the arguments we have to make based on precedent, right? Like if precedent is X, then we're going to make our best arguments under X. Maybe we'll argue the precedent should change and the law should be Y, but like we're going to make both those arguments, right? So
my personal view on it is something like there was a period of time that the current court is reacting to. And that period of time, you could, if you're being charitable to the current court, I think you would describe the previous period of time as being so detached from history and tradition, and there had been this accretion of precedent that were kind of subjective judgments. I'm not saying that they would think that all precedent fits into that category, but I do think they think a lot of precedent fits into that category of being unmoored. And then you just have this precedent that kind of, it gains its own momentum and it becomes its own thing. And like, are we really even talking about the constitutional principle anymore? But I think the unfortunate kind of irony of that is that as the pendulum has swung to the other side, I think that there is a version of it where it doesn't seem to me that history and tradition are bad things for judges to be thinking about. But I think I agree with Justice Barrett's concern that you're not going to be able to escape indeterminacy through history and tradition, right? You're not going to be able to find some place when you're judging law that's like you can open the history book and point to the thing, because even history and tradition, I mean, what all this made me think of, like I was just at the Federal Society's National Lawyers Convention, and IJ's Rob Johnson was on a panel about experts and about people appealing to experts and science and expert opinion. And one of the things that panel talked about is, even to say like the science says this or experts say this, I mean, you are going to end up arguing like which science, which experts, right? Like I do think that you get into the same space with history. Let's say you have a court that has an expert historian come on. There are at least dozens of historians who disagree with that historian about the history. And so you are not, even then, even if this was kind of the mono test, I'm not sure that you get to escape having to exercise the kind of judgment that courts have always had to exercise in our constitutional system.
Yeah, I mean, part of what sets judges apart from historians, not to say that judges can't use historical tools, is that they are uniquely tasked with figuring out how the pieces fit together in a constitutional order, right? So if I think about the Fourth Amendment, for example, which I do a lot, I agree with you, John, that like history, tradition, the mischief the constitutional provision was meant to manage, to quote Harry Potter, like all of those things factor into kind of grasping what is this constitutional provision about, what is it for and designed to do, and then you have to zoom out and say like, this is part of the Bill of Rights, which itself is part of the Constitution, which itself is part of like an Anglo-American legal tradition. It's like, as you zoom out and as you kind of get a sense of the context that's adopted in and the historical events that inspired it and all of that, you start to integrate everything and figure out how does this all fit together in a way that is coherent, right? And like if you are considering text in isolation, if you are just myopically looking at, well, you know, the year before and the year after this provision was adopted, you have 7 statutes that looked like that and 8 statutes that looked like that. And the 8 are more than the 7. So we got to go with that approach. Like that to me is just so far removed from what judges should be doing and what judging is, that it doesn't resemble constitutional law to me. And yet kind of here we are.
Well, and to build off that, like your comment about statutes, I think is well taken, because it does seem like a lot. Like when we're talking about text history and tradition, and the history and tradition normally is, right, like statutes or even ordinances. Like we weighed in, I think in Ohio recently on a Fourth Amendment case about administrative warrants, basically, as you know better than I do, Josh, like a free pass for the government to search rental properties. And, history and tradition starts playing into the analysis there. And you have the other side pointing to like a few municipal ordinances in Ohio in like the 1840s and saying, oh, look, this is tradition. And kind of my concern is when it comes to looking at ordinances and statutes as data points is now, and I'm confident back then, lots of the people passing the statutes, like members of the legislative branch, like they're not passing them with a careful eye towards whether they comport with the Fourth Amendment or the state constitutional analog or the First Amendment. Like they're just passing laws, and oftentimes they're doing so self-consciously with the expectation like, we don't know if it's constitutional, we'll let the courts figure it out. And I say that from personal experience because I have testified in front of a state legislature raising concerns with the constitutionality of a bill, and the chairman responded to me like basically like that's kind of outside our wheelhouse, right? Like our job is to pass the statutes, and the state Supreme Court is supposed to figure out if it's constitutional. And
I wish it weren't that way exactly. I think it would be great if you
learned that lesson.
Yes, I'm sure he's not the only legislator in the history of our nation who has that view. Maybe one of the few who said that said it out loud, so improvidently. But right, like that's just the reality of it. And so it just seems extraordinarily strange to suggest like, oh well, if there were enough, lawmakers back in 1830 who didn't care about the Fourth Amendment and didn't give it a second thought, then all of a sudden that gets laundered into what the meaning of the Fourth Amendment is today.
I mean, just to kind of tie this back to your first question of the pod, and kind of what has influenced us in talking about abolitionism. Like part of what's interesting about this moment in time is that we were just in this moment in time. Like when my legal career started, this was not the way, this was not at least the kind of like clearly dominant paradigm, right? It wasn't so entrenched. And I'm sure that 10 years from now, it won't be so entrenched. Like things move in cycles, right? Maybe it's not 10, maybe it's 20, maybe it's 30. But the point is,
it will be different.
This stuff happens in cycles. It's refined over time. Like maybe the kind of And Justice Barrett's concurrence that we've talked about was joined by like several other members of the court, from the liberal wing, obviously. But it just goes to show you that I think all it takes is, one seat to change, or justice like Justice Barrett to kind of continue refining her views and persuade other members of the court that, maybe this has kind of gone off the rails a little bit, and here's how to refine it, and who knows how it looks in 5 or 10 years. And I think at IJ we can play a part in kind of crafting the direction it goes based on how we present our arguments in courts.
For sure. So speaking of norms, traditions, we at IJ regularly interact with law students and young lawyers who are right out of school. Believe it or not, we were all lawyers, or baby lawyers and law students once, though I do have a hard time imagining Sam as a baby. I don't know about you guys, but I didn't really have any exposure to like the legal ecosystem before going to law school and then coming to work at IJ. And it would have been really helpful to have, I guess, a place for legal advice about those kinds of things that like you kind of only get often from getting tossed in or having like a really good mentor, or maybe having family who like worked in an area. A lot of those things there's not a course on, like faux pas or things to keep in mind as a young lawyer. Those things often come from just like good relationships you have where people are looking out for you. And so in the spirit of looking out for law students and fledgling lawyers, Josh, do you have any advice for people?
Yeah, I will admit that I proposed this topic, and I partly did because of some recent experiences with students and young lawyers, and thinking to myself, sort of like, what were the errors in thinking that led them to act in ways that might be like a little unprofessional, or just sort of like rub me the wrong way, right, and not reflect necessarily super well on that person. And just to kind of zoom out, I think like for me as a professional at a high level, I think of my relationships with people as effectively trades, right? Like I want us both to be winners, like have win-win relationships. And part of that is I recognize, like, so let's talk about Sam for a second. Like once in a while, probably more than Sam would like, I ping Sam and I'm like, hey, can I pick your brain, right? And Sam's always game. And I'm sure that if I asked him like every single day, he would say yes, maybe every day, because Sam is just a nice guy.
I would love it.
Right. But part of why I think Sam is willing to say yes, not just the fact that I'm his colleague, maybe he has a duty to do that I'm not aware of, is that like I hope Sam gets some value from talking with me. And like we sort of reinforce that, and we chat and we learn from each other. And I think if you sort of recognize that other people in the professional world have their own productive enterprises they're engaged in, their time is really valuable to them, right? And if you're going to kind of take time away from them, hopefully you're trading something in return, right? They're getting something out of that relationship, whether it's you'll one day be their colleague and so they're helping to train you, whether it's like you're kind of on an equal playing field and you can trade, knowledge and information, like as peers, direct peers in that moment. Whatever it is, it just feels like to me, part of what makes any relationship I have in the professional context valuable is that we're sort of all helping each other. And if that's the context I bring to my professional relationships, and a lot of people do, hopefully most people do, I think that students sometimes forget about that because understandably they're in a bit of a rat race in law school. Like it's really kind of scary to not have career certainty or career security. And so to be in the pursuit of career and to not have like that set up for yourself, and especially in law school, is a really scary time. You can be nervous, have a lot of anxiety you carry around. And so you're often just thinking like, what do I have to do to set myself up to have a career, right? And when you're doing that, it's understandable, but you might not be thinking about the person I'm trying to network with has a job, like has things they're doing every day, has a productive enterprise that is their priority, right? And so I've had, just to kind of like tell you where this is going, I've had students reach out to me recently for like maybe an informational interview, or maybe like, hey, I have I'm an undergrad moot court, right? Could you come like do a session with my moot court and like talk about oral argument? Which like happy to say yes to a lot of those opportunities the first time, right? And so yeah, I'll help out and chat with students and network. But I think I've had too many experiences where folks sort of like go one step too far, where it's like all of a sudden they're like texting me a lot, maybe like 8 p.m. with like deep philosophical questions about the law. And it's like, yeah, I get that you're curious, and like if we were having a beer, we might have a chat about that. But if you're kind of constantly messaging me after I've already kind of done you a solid, and you're not offering to do pro bono work, you're not applying to work at IJ, it just feels like at that point you're not respecting my time and respecting me and respecting the fact that like I have a lot going on and I have a family and I have other things, and so maybe in law school I was overeager in that way too, and so I'm trying to lend a lot of sort of grace to people who are in that position, but just sort of send the signal out that everybody's kind of busy, and if you want to be engaged with folks here at IJ, part of the reason that you presumably care to do that is that you like our work, and that requires us to be good at it and to devote ourselves to it, and we can't necessarily take every evening to answer a bunch of texts from folks who want to chat about like the philosophy of the First Amendment or that kind of thing. So that's one example. The other thing I'll say, and this rhymes with that and kind of the idea of respecting people as professionals, is that if you're a clerk or if you're like maybe like a newer lawyer, like sending work product that is of elite quality, at least within your capabilities, is really, really important, right? And I'm sure Sam's pumping his fist, and Sam might have thoughts on this too. But like if I ask you to do an assignment for me over the summer, or if you're just starting out as a lawyer at IJ and you're working on kind of a memo form or something like that, sending me a list of bullet points in an email, or sending me like a really poorly formatted document or one where the citations are kind of sloppy, signals to me that like I can't really trust the quality of the research, and that ends up just being a big waste of time because then I have to go do all the research myself because I don't really trust it, right? So I think part of conveying to somebody that you value their time and that you are committed to adding value to this relationship and trading value is that you have to signal to them that you've put in the work and that they can trust and rely on you as a colleague. And so I've had too many experiences where that wasn't the signal I got from a piece of work product, and I had to go do a bunch of work to fix it. So those are kind of two examples and maybe a few pieces of advice layered in there.
Sam?
Yeah, I'll second
Sam
everything.
was pumping his fist.
I was. Yeah. On the first of Josh's suggestions, I think the problem is they were just too approachable, Josh.
Yeah, I was going to say.
Nobody ever texts me at 8 p.m.
I'm just so magnetic.
Maybe I'll give up.
Yeah, you have to scowl more. It's as simple as that. But no, your second comment, I think, rhymes very closely with one of the three or so that I jotted down. Which is like drafts. And I think it probably applies to memos as well. I will also preface this by saying that most of these pieces of advice that I'll throw out into the ether are ones that I probably would have benefited greatly from hearing when I started out. I was not a very good junior associate for a couple of years at the big law firm where I was at. I just want to acknowledge my truth about that. But yeah, like drafts of briefs, for example. I mean, I think with very rare exceptions, whenever anyone is sending a draft of a brief up the food chain, it should be what kind of you, the drafter, think is at 100%. Like as far as you're concerned, this should be ready to PDF and file on ECF. Like maybe
it should in fact be a PDF.
Yeah, well, that would be ideal. Yeah. Depending on the situation. Well, let's not get sidetracked about that. Yes. But I mean, maybe not the table of authorities. Maybe a few citation kind of things here and there. But other than that, like. It should be the your best work. Like it should include a cover. It should include the table of contents. Like to Josh's point, like unless you've discussed it beforehand and this is the understanding, like there shouldn't be bits missing. There shouldn't be like, oh, I'll fill this in later. Like this should be like your A+ work product. Catch the typos, run it through brief catch, have it be substantively correct. Like if there's hard issues, like work through the hard issues. If you need to talk with your colleagues before the deadline, talk with your colleagues, get on the same page about it. Because I think even when a junior lawyer, oftentimes even when a junior lawyer's draft does reflect like, yes, this is 100% their best possible work. Even then, like there's a lot of work that will still need to be done. And that's fine, right? Like that is no knock on them. It is a learning process. But when
Sam is still going to rewrite a good chunk of your draft.
And that might be more reflection on me than on them. But it is the case, right? Like if you're a second or third or even fourth year lawyer, like you can put forth your best work and there will still be a lot of room for improvement. Just like for me, I will put forth my best work and I very much want even the more junior people on my team to be suggesting improvements because these things can always be improved. But when you're kind of the first line of drafting and you send something up the food chain that is not your 100%, but is your 70% or even your 80% or your 85%, then it's just exponentially harder for the person who's reviewing it, right? Because somebody's going to have to get it up to a real 100% fileable, state. And if it's not you, it's odds are, to Josh's point, like it's going to be someone higher up the food chain who has a lot of other things going on. And it does kind of raise questions about, can I trust this person, right? Like, is this a C+ quality draft because they didn't manage their time well, which is not good? Or is it a C+ quality draft because this is just the best that they can do? Which is also not good, but those are there are two very different ways to handle that, right? And so I would just very much urge folks, like there's always room for improvement. I'm not saying that I am the best drafter. Like my drafts can be improved, but like when you're sending it up the food chain, like from your perspective, it should be the best it can possibly be. I could go on for a long time, almost as long as I did.
I think this is good for people. This is good for people to hear. I mean, these are the kinds of things that I think, unless people go through an experience where they actually need that feedback, which ideally you get it before, so that you don't have the experience where you need that feedback. But unless people have that experience, or it's like a programmatic thing that people get it, I don't think that everybody necessarily gets that feedback.
Yeah.
So it's helpful.
For me, a lot of it does come down to recognizing that when you're working with others, the work you produce and the things you say is constantly sending signals about how, like, whether you value their time, whether you respect yourself as a professional. And like, these are things that you build a reputation with yourself and with your colleagues that it takes work to revive if you don't quite get it right the first time, right? So I think, like for me, I'm really, really impressed when somebody who's just starting out, who maybe doesn't like have all the legal tools in their tool chest to get everything right, sends me a brief that is like polished, or a memo that is polished, that seems like super well structured and just thought through. And like the person has made an effort to think about the different possibilities, the ways that the counter arguments to address those, think about questions I might have and kind of address those in the document, and just sort of like do the work of producing as much as they're capable of producing on their end before like I have to kind of come in and fill in some of the gaps, not in substance, Sam, but in terms of getting it to that 100% mark. And for me, a lot of that is just it's hard if you're someone who's just starting out. You don't necessarily know. I find editing quite hard. I mean, editing is not easy at all for me. It doesn't come. It's a skill like everything else, right? So you build it over time. But I certainly don't find it easy. And I think it would be made a lot easier if the drafter were to kind of do a lot of that A+ effort on the front end. But I do want to kind of circle back to one thing I said, which is about kind of communication and like overtaxing communication. And I want to be very clear, like my point is not that I don't enjoy frivolous philosophical discussions about the law. Here we are in Unpublished Opinions talking about potentially some of those things today.
Is it frivolous or is it a discussion about the law?
That's right. And certainly like there's a time and a place for those things. I mean, like if you come to our law student conference and we go out for a beer, like we are going to talk about those things, right? That's just what it means.
They're good things.
Yeah, they're good things. And like we at IJ are curious about them and like talking about them. But fundamentally, we are lawyers who are trying to do important work, and that requires a lot of effort and concentration and managing our time well. And I think just sort of like recognizing that context, respecting that, and if you want to be a part of that endeavor, signaling that like the best way to do that is to ask yourself, how can I contribute, right? How can I be a part of this endeavor rather than how can I insert myself into it? Those are very different things. Yes.
Yeah, that's all very helpful.
Can I throw one
Of
more
course
thing
you
out
can.
on the,
Yeah,
on
yeah,
the
of course.
table, John Wrench? One of them was going to be about timing and meeting your deadlines. I think that I hope that that's obvious, and we don't need to belabor that, though I have many astute things to say on that topic. But one other thing, which I think is worth saying because it may not be as obvious, is kind of in my view at least, kind of the responsibility of kind of every lawyer on a team, from the most junior to the most senior, to take seriously the unglamorous nuts and bolts of litigation. And I know Josh he's not fist pumping, but I feel like internally he's probably fist pumping. And by that I mean,
It's a scary image.
but by that I mean, take the time to know the local rules of your court backward and forward. Take the time to study the judge's individual practices. If you're a junior lawyer, sit down with a paralegal and actually do an e-filing every now and then. We at IJ have absolutely phenomenal paralegals. They are great e-filers. I'm confident many lawyers here at IJ have probably never logged into the CMECF system and e-filed, but they should. Everybody should. One, because sometimes there are late night emergencies and you'll have to do it. And two, because even if you're not the one actually kind of pressing the file button on CMECF, understanding how it works informs kind of how you put your documents together. Are the exhibits filed in a separate entry, or are the attachments? Do you have to do a proposed order? And I think it's easy for all lawyers, maybe junior lawyers who are just kind of excited to be lawyers, to think that they're too important to be the ones who are to take ownership over. Okay, we're sending out a subpoena. Is the witness fee in the right amount? Or we've written this super cool complaint with a cutting edge legal theory. How do we go about serving the defendant to make sure that we actually can ultimately have someone respond and reach a merits judgment? None of us are too important to spend the hours it takes to overthink all of that stuff. And that's something I think a lot of people may often need to be told. No matter how great your paralegals are, a lot of these procedural issues are hard, and they require thought that the paralegals are not going to. They shouldn't be expected to be putting into. That's your responsibility. The one other thing I'll say is always be nice and respectful to not only to your colleagues, John Wrench, I'm looking at you, but also to staff and everybody you're dealing with and paralegals. I will tell you just from experience, not that this happens very often at all at IJ, but on the rare occasions I've heard of particularly lawyers being kind of overbearing or rude with paralegals, I will remember their names forever.
Absolutely.
Yeah. And when I was clerking, it was kind of understood that the judicial assistant at the front desk, she would ask you, if you were rude to her, that was not a way to ultimately get a job offer. And rightly so, right? This is, to Josh's point, this is a collaborative team effort here, certainly here at IJ. I think this is probably more broadly applicable. And a kind of a hierarchical system where you think that you're too important to do the grunt work, or you want to kind of outsource it to someone whose job it's not, or kind of shirk your responsibility. That's in my view, that's probably not the best approach.
Yeah, you could say damning. I mean, it's this idea of the people who you can probably get away with treating poorly. That's how you treat those people. You can tell quite a bit about how someone actually is. That's all extremely useful. Mine are very short. If there's a work event with alcohol, it's probably not the opportunity to test the limits of an open bar. That's one of them.
That's very thoughtful.
Yeah. I'm not going to say I've learned that from experience, because I don't think that I've done I think that's fair. If you do it in a blaze of glory and don't remember it. I would say seek out mentorship, because I think a lot of this stuff, these are the kinds of conversations that I think if you find someone who is willing to kind of, whether they like you or because you're going to work with them and so it's better for them that you are not adult, they will probably give you helpful advice. And I would say asking for feedback is really helpful, especially when you're a younger lawyer, because sometimes there's planned opportunities for feedback, which are really good. I think IJ does do a really good job of people naturally giving feedback. But I think especially for younger lawyers, it's really helpful to receive feedback because it points you in a direction. But yeah,
on the mentorship point, I mean, I think one thing that I've been thinking about is that when you're early on in your career, the mentorship you would like is sort of like, if you're in law school, it might be like finding a career type of mentorship, right? Or like getting your first steps in the legal door type mentorship. If you are kind of a new lawyer in your first few years of practice, it might be mentorship on sort of like legal writing, how do different discovery tools work, some of the big picture nuts and bolts of like how litigation is structured and functions. But I think as you get further into your career, and I'm approaching a decade, you start to think through and seek out mentors for things like, how do you be a good lawyer and a good dad? Or like, how do you be a good lawyer and stay fit? Right? And just sort of thinking through how your life all fits together and how you can live a life well, given the demands of the job. And given the fact that there are a lot of important things in life and you're trying to balance all those things. And I think finding mentors who can help you navigate those things is just as important as finding the kind of career entry mentors in the front end.
Well said. So we'll finish with something that our listeners are always interested about, which is the stuff that you like. So I'm going to ask you for one legal and one non-legal, not illegal, but non-legal thing that you've been, I mean, that's a different podcast, that you've been enjoying recently, that's enriched you recently. Sam, do you have anything?
I was probably involved Dodecanese Islands in the 1912s.
Does it actually?
Well, I've been reading a very interesting book about that.
Okay.
But I think my answer may kill two birds with one stone.
Perfect.
To coin a hitherto unknown phrase, which is I started watching this Netflix limited series involving the assassination of President Garfield.
Oh yeah, I just saw that on Netflix.
I'm two episodes in, and it is just delightful. Great actors. Ron Swanson from Parks and Rec. Yes, precisely. Plays Chester Arthur. The guy from Succession, kind of the goofy husband / boyfriend of the daughter of the patriarch.
Tom. Is this Tom?
Yeah,
from
McFarland.
Yeah.
So he's the Charles Guiteau, who, if the heavy-handed foreshadowing is to be believed, is the assassin of President Garfield.
He was obsessed with Garfield, right? Is it something like that?
Yes, and I will leave it at that so that Josh has a chance to weigh in as well.
I'm just pointing at John that I have an 11 o'clock in red.
Oh, I thought you were showing me a picture of your golden retriever. No, I'm joking.
We should spend 10 minutes talking about the golden retriever.
I was like, oh yeah, me too. I was showing him my dog.
Okay, so the non-legal thing I've been consuming is my dog. No, I'm just kidding. So I read this fantasy author named Joe Abercrombie. Have you heard of him?
I think that you mentioned him on a podcast quite a long time ago.
Yeah, I believe that that makes sense.
Were there dragons involved with it?
That might be the Bone Ships.
That was the Bone Ships.
Yeah,
that was the Bone
great
Ships.
trilogy,
Okay.
Incredible trilogy. If you like kind of like piracy and like anyway, we can talk about that. It's really great. But world building is fantastic. But Joe Abercrombie is sort of like a dark fantasy writer. So a lot of his stuff is very kind of war based and a little bit gory, but it explores like kind of complex characters who are haunted by their own flaws and by the kind of state of the world and that kind of stuff. So it can be grim, but he has this world he's built that was based in the first Law trilogy, the first kind of trilogy he wrote. He's now written like 9 books in this world, right? And so I'm reading a spin-off book called Heroes from this kind of like world he's built. And the fun thing about the book, it's 500, 600, 700 pages. It feels like a big brick when I pick it up, but it's a book that's quite long about different characters' points of view during a 3-day battle. So the whole book takes place over the course of 3 days.
That's cool.
And it has been really good so far. It's been giving me perspective on characters that kind of seem like minor characters in kind of the main trilogy and the subsequent trilogy that follow it. And so you're getting like deep perspective on these kind of characters that you otherwise wouldn't have got a sense of who they are, like what they're dealing with during the main plot of the story. So Joe Abercrombie is just a delightful writer. I mean, he's compulsively page turning, and you can't put his books down. So if you just want something that will take you through the end of the year and keep you gripped, like pick up the first Law trilogy and start reading that. But my book right now is The Heroes. The other thing that I've been consuming that is sort of legal is this morning I read Tim Sandifer's article, Originalism and the Illusion of Objectivity, which is just sort of like a nice critique of originalism from that rhymes with a bit of what Justice Barrett said in her concurrence in the Ulster case. So I think if you're looking for kind of a perspective on why some of modern originalism might have flaws or might have gaps in it, I think Tim's article is quite good on that, and we can link it in the show notes. And it was also recommended in Will Bo's What You Should Read This Week post. So
awesome.
Yeah.
I'm reading Professor Kilmar's Born Equal, his new book it traces 1840 to 1920. So it's like Civil War, abolition, Civil War, Reconstruction, 14th Amendment. And it's part of like his trilogy of books about the American Constitution. So I like any book that focuses on like the 14th Amendment era because I think that it gets a little bit less attention than it should in the way that we think about the Constitution. That's been good. And then I'm also, this sounds highbrow, but I promise you it's actually the opposite. I decided to start rereading Shakespeare because I read Shakespeare in school, and I remember enjoying it, but I wasn't like in undergrad really probably reading much Shakespeare. I certainly wasn't reading a lot of it in law school. I say certainly as if no one does that, but I definitely was not. And I was reading it recently and taking my time and just really enjoying it. And so I was thinking I should probably, as an adult, like slow down and enjoy something and accept that. I think this is true. Like some things are extremely famous and have survived the test of time because they're actually like really, really good.
Do you read it out loud to yourself?
No, I have not. Though I do try. Someone suggested imagining that you are kind of watching it on a stage because it can be helpful. To like, because obviously that's how he's writing it. So I'm reading Hamlet right now and I'm really enjoying it. 10 out of 10. I think I'm the only person with that opinion that thinks that Hamlet is a work of art. But
I will just say that I often, whenever I try to read Shakespeare, I just feel like I'm one of those people who just isn't smart enough for it. I just don't think, I just, I'm looking across the hall at our colleague like Andrew Ward, who I feel like could just pick up King Lear and I have read King Lear, but he could, read it comfortably. And I think that whenever I read Shakespeare, it is deeply uncomfortable and like grinding for me. And I feel inadequate.
Well, you're not. And if we could impart anything else to show, that will be it, is none of you are inadequate.
Stirring words.
Even if you can't read Shakespeare. No, everybody can do it. And I think that was one of the things for me too, of like, I wouldn't say that it was easy, but it was like taking time and then trying to do it in little bits was enjoyable. But so Sam and Josh, thank you so much for being on the show. To our listeners, I hope you enjoyed our conversation. Be sure to tune into our next episode. Until then, that's just like your unpublished opinion, man. Get some hot, get myself a gun and shoot myself a